Everybody ready? Mr. Conklin, you ready? All right. Very good. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez. I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney. In all cases, since the city has a burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city attorney will swear in any witnesses. The first matter on the agenda today is going to be a legal argument by counsel for the respondent, counsel for the city. However, there is another matter on the agenda, so Mr. Trask, let's just go ahead and swear anybody in who's going to speak.
Anyone that's going to speak on either of the agenda items, please stand up, raise your right hand, be sworn under oath. Swear the testimony you're about to give is going to be, the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Okay, thank you.
All right.
It's not necessary.
Yeah, Mr. Conklin, why don't you come on up? The first matter on today's hearing is case number 2023.3600 for the property at 414 140th Avenue East, Madeira Beach, and this is a hearing on a motion for rehearing, motion for clarification, and motion for an extension of time for compliance. I received your motion, sir, and I asked for it to be set at a public hearing, the next available public hearing, that's today. Have you discussed with Mr. Trask how you guys want to go forward today, just from a procedural standpoint, time-wise, or anything like that? All right. Why don't we do this? We've got plenty of time, so I'll give you 10 minutes, but if you need more than 10 minutes, that's fine. Mr. Trask, I'll do the same thing for you. If you need more time, just let me know. Mr. Conklin, I have read everything, but please go ahead and share with me anything you'd like to share.
Well, thank you very much. If it may please the magistrate, the motion for rehearing, motion for clarification is largely based upon paragraph 12 of your order, where you, and I don't mean, other than making a record, I know you wrote the order, so I'm preaching to the choir. But it said that there were numerous life safety issues of the improvements, including but not limited to 2 bedrooms on the first floor, did not have secondary egress, operating smoke alarms, there was unpermitted water heater installed, there exists improper wiring, electrical wiring, plumbing throughout the first floor. There were multiple penetrations and openings between the first and second floor. There was a washer and dryer within the closet without proper dryer ventilating system and an unpermitted air handler. And then if we turn to the next page, paragraph 21, says respondents shall correct the above stated violation within 30 days by taking remedial action as set forth in the notice of violation stated on the record at the hearing, which is to get an after-the-fact building permit for the improvements and work done on the first floor, or remove all unpermitted work so as the structure is fully code compliant and the life safety issues no longer exist. I was informally, that the only permit that would be issued was a demolition permit. So reading from paragraphs 12 and paragraph 21, it's like I assume that my clients would have available to them to apply for a building permit to correct the life safety issues, as opposed to demolition of the entire improvements to the first floor. That's what I'd feared when I first gave the hearing, and of course made that in my post-hearing brief talked about the fact that, while there were, there was evidence presented as to life safety issues, and it's like, well, if the ultimate result is a demolition of the entire, improvements to the first floor, there were improvements that did have a permit, and the one was the wet bar. So, and previously, for example, the electrical box, that had been put in for years. It had never had any other location than other on the first floor. And the water heater, of course, was a replacement of an existing water heater. So the point being, I submit that I wanted clarification as to the order. Are we getting a permit to correct the life safety issues and bring that up to code? Or is this truly my client's only alternative is a permit for demolition? And then there was a secondary issue which the city indicated they had no objection, and that was we were to correct the above violations within 30 days, and in my motion I set forth that we requested a 90-day extension as the hurricane intervened, and the city in its response said that they had no objection to that request.
All right, thank you, Mr. Conklin. I understand your arguments. Is there anything else? And I'll give you the last word in a minute, but is there anything else you'd like to tell me right now?
Other than my clients also sent a wish list, which I know it's not part of a hearing, but I should comply with it. They wanted it, and we're making a record. Anyway, it said that their wish list for the lower level was convert 2 bedrooms into 2 garage doors with rails, automatic openers, electrical outlets, lights, and fans. Keep both spaces as storage and garage. Keep the finished 433 square feet as is with bathroom, AC, water heater, and electrical service. And if need be, they'll take out the kitchen stove, the fridge, but they'd like to leave the sink and convert the space to a wet bar, which was under the approved permit. So that is their wish for compliance. Thank you.
Thank you, Mr. Conklin. I appreciate that. Mr. Trask?
So did you have an opportunity to review the response that we filed?
Yes, I did.
Okay.
Yeah, I'm sorry. I reviewed all the written filings that were officially filed, so Mr. Conklin's filing and your response.
All right, I just wanted to make sure we have that clear for the record. So first of all, with regard to the motion for rehearing, the motion for rehearing fails to follow Florida Rule Civil Procedure 1.530 because it fails to state with particularity the points of law or fact that the respondents contend that the special magistrate overlooked or failed to consider. It specifically just uses that language, motion for rehearing, without addressing it in any way whatsoever in the motion itself. The case that was cited in the response was the Balmoral Condominium Association versus Grimaldi case, which is reported at 107 Southern 3rd, 1149. It's a third DCA case issued in 2013. That specifically provided that motions for rehearing are strictly limited to calling the special magistrate's attention without argument to a matter that has been overlooked or a matter that the special magistrate has failed to consider. With no specific facts or law that was included in the motion for rehearing, I think it's appropriate for denial. As for the motion for clarification, I think the motion for clarification also should be denied. Although Mr. Conklin referred to certain findings of fact in the order the U.S. Special Magistrate issued, paragraph 21 was very specific as to what needed to be done to bring the property into compliance. Specifically, it says that you needed to take the remedial action set forth in the notice of violation. The notice of violation provides that the corrective action is either the property owner and/or a licensed contractor will need to apply for and obtain an after-the-fact building permit to comply. If a permit cannot be obtained, the structure must be removed. So it's very, very specific in the notice of violation that U.S. Special Magistrate were referring to. Also, in your paragraph 21, I think it's very clear. It doesn't say remove some unpermitted work. It says remove all unpermitted work so that the structure is fully compliant. So I think that is clear. There needs to be no further clarification on that. Then as for the response to the request for compliance. We do recognize that we did have a hurricane. We have had issues here locally on this coast of Florida. There has been some damage to homes in Madeira Beach. There has been some difficulty getting contractors, it's my understanding, to get work done. So I had reached out to Mr. Conklin before this hearing and advised him that the city had no objection to a 90-day extension of the compliance date till December 28th to gain that compliance, subject to the fact that the first floor is not habited. We want to make sure that it's not rented or used in any way. There are life safety issues, as you have made a specific finding on, and we do not want people living or staying on the first floor with those life safety issues there. So it's the city's position then that the motion for rehearing should be denied because it fails to comply with the law. The motion for clarification should be denied because the order was very specific as to what compliance was required, and as for the extension of time, the city has no objection so long as it's not inhabited and have a compliance date of December 28th. That's the city's argument.
Thank you, Mr. Trask. Mr. Conklin, I'll give you the last word on this.
My clients have represented to me that they will not have anyone occupy the first floor during this time period to December 28th, and so we'll comply to that portion. As to paragraph 21, Mr. Trask has accurately responded, except for the fact in the next to last sentence on paragraph 21, it says "or." So it's get an after-the-fact permit for improvements and work done on the first floor, or remove all unpermitted work. So the "or remove all unpermitted work" is what I understand to be a demolition permit. In other words, remove everything from the first floor except the posts, where the first part of it says, which is to get an after-the-fact permit for the improvements and work done. And as I say, if we're taking out the life safety issues, my clients are more than willing to do that and apply for a permit for that. But it's not their understanding that's the permit they'll get. Thank you.
All right, thank you, Mr. Conklin. Mr. Trask, I just want to make sure, is there anything that the city believes I need to change in regard to paragraph 21? Is there anything the city believes it's unclear about that paragraph?
We don't think that it's unclear. We think that all the unpermitted work either needs to be permitted by a way of getting a building permit or getting a demolition permit.
Okay, I guess what I'm asking is, does the city want me to change that language? Is the city concerned? Because I'm not inclined to grant the motion for rehearing, and so this order is going to stick for wherever it heads from here. So is there anything and I would give you and Mr. Conklin the opportunity to put together a proposed order if you think something needs to be clarified in regard to paragraph 21.
So in a perfect world, the answer would be yes. And that would specifically provide that they are to get an after-the-fact building permit for any work done on the first floor. And if it cannot be obtained, that a demolition permit would be obtained.
All right, then here's what I'll do. I'll go ahead, I'm going to deny the motion for rehearing. Grant the motion for clarification as you just stated it, Mr. Trask. I'll also grant the 90 days subject to the agreement that it sounds like the party has. I would like Mr. Trask, you to prepare the order, but send it to Mr. Conklin for his review.
Okay.
And then you guys submit to me a mutually agreed upon order. Does everybody, Mr. Conklin, you understand my ruling?
Yes, sir.
Okay. Mr. Trask, you understand my ruling?
Yes, I do.
And I'll get that order entered as soon as it comes to my desk.
Thank you.
All right, that concludes the, and Mr. Conklin, you did a great job for your clients. Obviously, as I said in the outset, I can't grant a building permit, so I listened to their wish list, but please express to them that that's just not something that's within my purview, but I certainly did hear that, and I know the city heard that as well, so thank you. All right, let's move on to the next case, which, yes, absolutely. Let's move on to the next case, case number 2022.3467. Property located at 13436 Boca Ciega Avenue in Madeira Beach. Go ahead, Mr. Trask.
So The special magistrate order that was entered on March 27, 2023 has come into compliance on this property, Acquisition Group LLC, 13311 Second Street East. It came into compliance on August 2nd, 2023, and we're asking for you to enter an order finding the property in compliance as of that date. I have not had any communication from the property owner or its representatives. So I'm not really sure, if they have objections or not. Obviously, it's in compliance. They wouldn't have objection to that. As for the date and time, that is, that would be something else. This property, as you'll remember, was a property that had to be demolished, and in fact was demolished. And I think there is a photograph in the packet listed. Well, it's the one that's the vacant lot that just looks like it's all dirt with a sign posted in it. I'm not sure what page number that is in the packet, but the property has been demolished. It is in compliance as of August 2nd.
All right, and I just want to make sure, August 2nd is the date?
Yes.
Okay. Is there anyone here on behalf of the respondent or property owner for 13436 Boca Ciega Avenue? All right, I guess we'll open it up for public comment, Mr. Trask, or is there? No, okay, we'll go ahead and open it up for public comment. Is there anyone from the public that would like to comment on the request for an order of compliance in regard to the property located at 13436 Boca Ciega Avenue? Okay, seeing none, I'll go ahead and enter an order of compliance as of August 2nd, 2023.
Thank you.
Is there anything else before me today, Mr. Trask?
No, there is not.
That concludes today's hearing. Thank you all very much.
Thank you.